this video, we'll be covering chapters 6, 7, 8, 9, part of 10, and 12 for the Business 245 Law Final. We'll start out by looking at contract law and the four elements that are needed. The first is offer, the second, acceptance, the third, consideration, and finally, capacity. There are 6 general rules for offer and acceptance. The first, a contract doesn't exist until an offer is made by one person and accepted by another. The second, an invitation to do business isn't an offer. The third, an offer must be communicated. Fourth, an offer can lapse if a specified time period has expired, a reasonable time has expired, or either the offerer or offeree dies or becomes insane. The fifth rule is that an offer may be revoked at any time prior to acceptance. However, there are a few exceptions. One is that if the offer has been made in writing and is said to be open for a specific time period under seal. The second, if you have an option contract. Rule number 6, and our final rule. A contract becomes binding the moment an offer is accepted. Now that we're done offer, we'll look at acceptance. We'll look specifically at the analysis to determine time and location of acceptance. And there are 4 steps in determining the exact moment the contract came into existence when separated by distance. The first, identify the method of communicating acceptance. This could be anything from emails, actual snail mail, or any communication on your phone. The second, ask, is this an accepted method of communication? It is an accepted form of communication if it is the method specified in the offer. For example, if the person asks you to please reply by email. It is also accepted if it is the same method as used in the offer. For example, asked by a mailed letter and accepted with a mailed letter. The third step. If answer to step 2 is no, then acceptance occurs only when received. For example, if the person is asked to please respond by email but they send a mail letter instead. Step 4. If answer to step 2 is yes, then follow the rules for each method of communication. Mail. For mail, you can use the mailbox rule. If mail is an accepted form, then the very moment you drop the properly addressed stamped mail of acceptance letter in the mailbox, the contract is formed. For fax or telephone, the acceptance occurs when the communication is received. Example, if you get a fax and the person receives it in their hands, or when you say, I accept on the phone. For email, when the addressee is aware of and capable of retrieving the email. For a voice message, it's simply at the time when the person is aware of the message. This concludes our second element of contract law. Now we'll move on to consideration. Consideration can be defined as the promise of a price or benefit to be paid in return for another's promised act or benefit. When looking at consideration, you have to make sure that it's flowing both ways in order to have a binding contract. However, keep in mind that courts don't correct bad deals as long as consideration is present. Now moving on to some special rules. The first one is that post-consideration is no consideration. The second, a gratuitous promise doesn't provide the basis for a contract. And third, a promise to perform a pre-existing contractual obligation doesn't constitute consideration. Now we'll look at the concept of estoppel. Estoppel is a legal principle that bars a party from denying or alleging a certain fact owing to that party's previous conduct, allegation, or denial. In this example, we'll look at a real estate president who was fired with what was said to be cause for dismissal, but in reality, there is no basis for cause. The plaintiff said that they weren't going to bring up cause, but did end up bringing it up in trial. You can use estoppel as a defendant, but not as a plaintiff. Quantum merit. This is simply where consideration is promised, but not specified. The use of a seal. The use of a seal can be a substitute for consideration. It shows the intention to be bound to the contract. For example, a classic case is when you're mailing a letter and you put your wax seal on it. This sums up the third element of consideration. Moving on to the fourth and final element, capacity. This is the ability to have a meeting of the minds. When looking at capacity, a definition we need to know is a void contract. This is a contract which never had a legal existence or never became binding. In other words, it's dead. Second, we have a voidable contract. This is a good contract that can be brought down because of a defect. So you could say it's killable. Repudiation. This is the process of voiding or killing the voidable contract. Now we'll look at minors, anyone who is under the age of 19. A contract entered in by a minor isn't enforceable against the minor, but may be enforceable against the other party. But there are a few exceptions. 1. Necessaries. If the contract is for the actual requirement of the minor, it is binding. The second exception is a beneficial contract of service. These are contracts of employment or apprenticeship found to be for a minor's benefit. A good example of this concept is the example of John Tonelli. He was a junior hockey player in Ontario when he was 18 years old. The Marlboros got him to sign a contract at the age of 17, saying that he had to play until he was 20 years old. Once he went to the NHL, he had to pay back 20% of his earnings for the next 3 years. This happened in the 70s, and they started a rival hockey league against the NHL. A lot of younger players were signed to that new league, and Tonelli decided to accept the offer from Houston and tells the Marlboros that he is leaving. The team said that he is not allowed because he signed a contract. Tonelli said, "I repudiate. It can't be binding because I'm a minor." The Marlboros said that there are exceptions to this contract of service. Tonelli's lawyer specifically used the word beneficial. He said that the contract is not beneficial to John Tonelli. The courts agreed and said that it wasn't beneficial because he wouldn't be able to develop as much in the current league. And so, it was not a beneficial contract of service, and he does have the right to repudiate. Special rules for minors. If a minor repudiates, they must return the goods regardless of the condition. You can't use tort law if the activities in the contract are the same as the tort. Third, what happens when a minor reaches the age of 19? Well, was the contract for a necessary? Was the contract of a long-term or ongoing relationship? You have the right to repudiate anything else besides the first two. Now I'll move on to insane or intoxicated people. A contract made with someone not of a sound mind is voidable. However, there are special rules. If you're going to repudiate, you have to prove that you are incapacitated at the time of entering into the contract. If you're going to repudiate because of incapacitation, it must be known to the other party. And if you're going to repudiate, you must do it promptly after coming out of incapacitation. This sums up the fourth element of contract law. Now, mistake. There are a couple definitions that we need to look at when trying to understand this concept. The first is rescission. It is an order of the court to cancel or revoke a contract, restoring the parties as much as possible to their original positions. Rectification. This is a correction by the court of a written document to accurately reflect the contract made by the parties. In other words, the correction of a written term. There are a couple of reminders we should look at when looking at mistake. Courts are reluctant to rescind contracts. For one, it devalues the future contracts, and it can result in unfair results for third parties. The legal test for rescission. Would a reasonable person have relied on the term as being intentionally made when entering a contract? If yes, there is no binding contract even with the mistake. B. Mistake in recording terms. The court may grant rectification if there is a clear, complete, and unconditional prior agreement between the two parties, or if there is no evidence of change in the agreement from the time it was made to the time it was put in writing. The last one is the difference between the original agreement and the written document can be explained by an error. Moving on, mistakes in interpretation of terms. This concept can most easily be explained by using an example. In this case, you hired someone to paint your house while you were gone on vacation, and you asked them to paint your house blue. However, when you got back and saw what color they had actually painted it, it was the most hideous shade of blue you'd ever seen. In their mind, they had done what you'd asked and painted the house blue. However, it was just a misinterpretation of the terms that had been established in the contract. Next, we'll look at mistaken assumption. The courts may grant rescission if the mistaken assumption is so material that it alters the very nature of the contract. Moving on to doctrine of non est factum. If you are blind, illiterate, or have language issues, then you can rescind a contract. Misrepresentations. The first one that we'll look at is fraudulent misrepresentation. This is an inaccurate representation of fact made without any belief in its truths, with the intent that the person to whom it was made should rely on it, and that person did in fact rely on it. The victim must prove the following. First, the representation was made by wrongdoer to victim. The representation was a statement of fact. Representation was false. The wrongdoer knew the representation was false, or made it recklessly without knowing if true or false. And finally, the wrongdoer intended that the victim be induced to enter the contract by the representation, and victim was so induced. For example, let's say you're buying a used car from someone. You ask them, are there any problems with the cooling system? That person may very well know that there's problems with the cooling system, but they insist that there aren't any problems. They're intentionally going out of their way to deceive you, and that would be fraudulent misrepresentation. Now, we'll look at the remedies for fraudulent misrepresentation. You can get rescission and or damages for the tort of fraudulent misrepresentation. Second, negligent misrepresentation. This is an incorrect statement of fact made without due care for its accuracy. In order to have liability for negligent misrepresentation, there must be a duty of care owed, breach of that duty, and reliance of the representation. Again, we'll look at the remedies. You can get rescission and or damages for the tort of negligent misrepresentation. The third, innocent misrepresentation. This is an inaccurate representation of fact made without any intention to deceive, but on which the victim has relied in entering into the contract. The remedies for innocent misrepresentation are different than the other two. If innocent misrepresentation is made during negotiation and not a term of the contract, then you can get rescission but no damages. If innocent misrepresentation is a term of the contract, then you can get rescission and or damages for the breach of contract. Silent misrepresentations. If a contract is of uberame fide, meaning of utmost good faith, there will be a duty to disclose material facts, and failure to do so may be a misrepresentation. There must be a special relationship of trust in order to have a contract of utmost good faith. Certain classes of contracts have been found to be contracts of utmost good faith. Examples include contracts within a fiduciary relationship, insurance contracts, and contracts within partnerships. General notes. Where misrepresentation led to the formation of a contract, such a contract is in essence voidable. The contract may remain a good and binding contract if the victim of the misrepresentation doesn't exercise the option of seeking rescission. The right to rescission may be lost to the victim of the misrepresentation if he or she fails to renounce the agreement promptly after discovering the misrepresentation, adopts or affirms the contract's bywords or conduct, takes further benefits under the contract, has resold property to a third party who has purchased in good faith and for value, or in sale of land where the transaction is complete and title to the property has been transferred. Next, we'll look at interpretation of contracts. We'll first look at express terms. This applies where there is an ambiguous or disputed term or provision of a contract that has been specifically discussed and agreed upon by the parties and has been expressed in the oral or written exchanges between the parties at the time the contract was made. Step 1. Strict interpretation. Look to the ordinary or dictionary meaning of the disputed term. Step 2. Liberal interpretation. What would a reasonable person determine is the intention of the parties based on the following factors: surrounding circumstances, past practice, negotiations, special or specific use of the term, credibility of the parties. Next, missing terms. This applies where a term was supposedly part of the original agreement but isn't included in the final written contract. The parole evidence rule. Where the language of the written contract is clear and unambiguous, then no intrinsic evidence will be admitted to alter, vary, add to, or contradict the written contract. But like always, there are a few exceptions. Misrepresentation, mistake, ambiguity in written terms, written agreement isn't a whole argument, collateral agreement, condition precedent, and subsequent contractual modifications are all exceptions to this rule. Implied terms. Applies to a term that hasn't been included in the agreement and a reasonable person would have included it. Primary criteria. Is the term reasonably necessary to implement the intention of the parties having regard to the surrounding circumstances? Now we'll talk about discharge of contracts. How to kill or end a contract. The first way you can kill a contract is by performance. If you fully fulfill the obligations of the contract, you'll kill the contract. The second way is by agreement. This is a mutual agreement to terminate. Basically, you're entering into a waiver contract, which is a contract to terminate a contract. Replace with a new agreement. This can be done through novation with a material change, novation with change in parties, or through accordance and satisfaction, where obligations can't be met and a settlement is made to resolve the dispute. Terms of discharge and contract. Number 1. Condition precedent, a future event that must happen before it's binding. 2. Condition subsequent, a future event that makes it binding only if the future event occurs. The third and final way that you can kill a contract is by frustration. This is where it becomes impossible to carry out the obligations of the contract. There are 3 key rules for frustration though. The first being hardship is not frustration. Frustrating event must occur after the contract is formed. And the final one, frustration can't be self-induced. I hope you found this video helpful. Thanks for watching.